All right, and on that note, it is 1 o'clock as well. So again, my name is Lisa, and I am here to introduce the Magistrate Abbey King. They're from the Geauga County Probate Juvenile Court, and you'll be presenting on the topic you can see on the screen, domestic violence and abuse, neglect, and dependency cases. So I'll go ahead and let you take it away.
Hi, everybody. I'm Magistrate King. Thanks so much for having me. Just first off, a couple disclaimers. I am not very tech savvy, so I apologize in advance for my PowerPoint being somewhat rudimentary and basic. I don't have all of those fun pictures like the last presenter did, but I did my best. So, and also I've never presented on Zoom before, so hopefully everything goes off without a hitch, but wish me good luck. So I am Magistrate King. I work at the Geauga County Probate Juvenile Court for Judge Grandel. I've been here since January of 2018. I handle both juvenile and probate matters. For purposes of this presentation, we're just talking about juvenile matters and the things under that umbrella. Prior to coming to the court, I worked as an assistant prosecutor here in Geauga County for Dave Joyce and Jim Flays, and I handled the child abuse, neglect, dependency cases, prosecuting those in juvenile court in front of Judge Grandel prior to coming to the court. And I do have a background in social work. That's what my undergrad is in, and specifically child welfare. So I was very flattered to be asked to speak today and to give a presentation. So this is the presentation that I've developed for this conference. So hopefully people find it somewhat useful and helpful. So let's get started. I have been asked to specifically talk about when we have abuse, neglect, dependency cases here at the court, and those cases that involve domestic violence and the dynamics in domestic violence. What challenges do we face here at the court, specifically in those cases with regards to the domestic violence element that is added to the whole picture? So I'm going to start by giving everybody hopefully a pretty brief overview of the law, because I figured we needed to start there and kind of understand some of the basic procedure in order to kind of understand how the dynamics then play into that. So let me see my slide. Here we go. I don't know. How do I get to the next slide, Lisa, do you know?
If you just hit maybe like your arrow button, I would assume on your keyboard.
There we go. Perfect. Yep. I didn't hit it hard enough. All right, thanks. All right, so with regards to the abuse, neglect, dependency cases, those are cases that are filed by our local children's services agency here in Geauga County. It's Geauga County Job and Family Services, specifically their Child Protection Service Unit. So in those cases, we deal with Ohio Revised Code Chapter 2151. And this chapter sets forth a timeline for these cases that the court has to follow. And the timeline is as follows. We have about 1 year to resolve the case. And if we don't resolve the case in 1 year, which I would say the majority are not resolved within 1 year, the parties or the court can ask for 6-month extensions of jurisdiction, and there can be up to 2 6-month extensions. So the maximum amount of time that a case could be pending in court would essentially be 24 months. And that 2-year deadline is what we call the sunset date. And the sunset date is 2 years from the date of the filing of the complaint by the agency, or from if a case comes in as an emergency, that means it comes in as an emergency first. We issue an emergency ex parte order, and then we get into the court on next business day and the complaint is filed. So sometimes the earlier date is that grant of emergency custody. So we go from whatever date is earlier, whether it's the grant of custody or the filing of the complaint. There is a 12 out of 22 months provision in this chapter. And basically, I think I put it in my slide, the direct quote from the statute reads, if a child has been in the temporary custody of a public children's services agency for 12 or more months of a consecutive 22-month period, then this statute mandates, it's got that mandatory shall language in it. It says the agency with custody shall file a motion requesting permanent custody of the child. So basically this statute is requiring JFS to file a motion for permanent custody if a child has been in temporary custody of the agency for 12 or more months out of a past 22-month period. So that timeline stems from a federal legislation, and the legislation was enacted in 1997, and it's the Adoption and Safe Families Act of 1997. And that sets forth that whole 12 out of 22 month provision. And the purpose behind that fairly quick and expeditious timeline is to achieve legal permanency for kids and to prevent them from languishing in foster care for an extended period of time, which a lot of kids were doing so in the 70s, 80s, and 90s before this legislation enacted. So the whole point is to move things along so kids aren't sitting in foster care waiting for mom and dad to get better, waiting for mom and dad to get off drugs for too long, for an extended period of time. The legal permanency, when I put that in quotes, this is a way to give a child legal permanency such that you can close a court case and you don't have to have it open, whether it's through legal custody to a relative or permanent custody to the agency. It's a way to tie up loose ties for this child legally. So on paper, they have, legal permanency and a custodian that has legal custody and can move forward, in through the age of majority. The reason that I put it in quotes is because a lot of times, unfortunately, the permanency really is only legal because the outcomes can still disrupt legal kinship, legal custody, and kinship placements. They can break down and fall apart, and people decide that they can't take care of kids anymore, and so the kids go back into the custody of the agency, and we have to find someone to take care of them. Adoptions are wonderful, wonderful things, and they are the best part of our job here at the court, and we absolutely love them. Unfortunately, those can still break down, and I've been here long enough to see adoptions that I was a part of then come back in because they've broken down. And it happens for a whole host of reasons, and it's heartbreaking, but I just want everybody to know that even though we do achieve legal permanency at the end of that 24 months, it doesn't always end up being permanent in reality. So a brief procedure, an outline of the procedure. When a complaint is filed, a case comes into us as follows. Either the agency files a complaint alleging abuse, neglect, or dependency, or the agency calls the judge or myself after hours. It's called an emergency ex parte order. They call us, they say, we found a child in destitute situation. There's no parent to take care of them. Mom's in the hospital, dad's in prison, and there's no family available. We need emergency custody. So then we would grant emergency custody and we'd be in court the next day. So that's one of two ways that a case could come in. Once a case comes into us, we have an initial hearing. And at the initial hearing, that's the time when the judge or I review everybody's rights. We review the powers of the court and variety of the orders that the court has the power to order and enforce. We make temporary orders to govern the case and keep kids safe until we can get to the upcoming hearings. We appoint attorneys for parents if they wish to have them, and we appoint a guardian ad litem for the child. Then the case comes back in for a pretrial, and a pretrial is a hearing where the agency and the agency's attorney meets with the parent's attorney, and they review the evidence and they decide if they can amend the complaint language and essentially come up with an agreement about how the complaint is written, and that the hope is that mom and dad would plead true to the amended language, and that we would have basically an agreed upon adjudication moving forward. We usually have up to 2 pretrials. Every once in a while, I will allow people to have a 3rd pretrial if I think it's going to be beneficial and a good use of everybody's time with getting an agreement. 50% of cases usually plead at the pretrial, and then 50% don't, and we go to a full adjudication hearing where we have a trial and the agency puts on evidence to prove the allegations that they stated in their complaint. If the case is adjudicated through a trial or a plea, then the next step is disposition. And then that's when we make the formal long-standing orders for the case to adopt the case plan and the goals and objectives in the case plan and the specific tasks that we are asking the parents to engage in to essentially rehabilitate them and to reunify, which is 99.9% is what usually our goal is. Disposition hearing, from the time the emergency custody comes in or the complaint, disposition needs to occur within 90 days or the case is dismissed. And that is a timeline that's prescribed in that Ohio Revised Code, Chapter 2151. So we got 90 days to do initial hearing, pre-trials, adjudication, and get a disposition. And again, it's designed to move things along because we're trying to maintain and preserve the safety of the children, and the strict timeline is there to make sure that people aren't, taking their sweet time and not making this case a priority. Once it's we have a dispo hearing, we have review hearings usually every 3 months, but they could be at any interval. And then of course we have status hearings if an issue arises, or we have motion hearings if somebody files a motion for something, and we have show cause hearings along the way if people are violating court orders and not complying. And then the possible outcomes at the end of the day when these cases resolve and close, if they go the full 24 months or any really piece of time, the possible outcomes are reunification with a parent, legal custody of the child to a relative or kinship. We can do what's called a planned permanent living arrangement, and that's for kids who are 16 years or older. And that's for kids who can't go home for whatever reason, but they don't want to be adopted. So PPLA is what we call it, and it's basically like placing the kid in the long-term legal custody of the agency until they age out at 18 or when they graduate. And the other outcome is termination of parental rights, which can happen through a voluntary surrender of parental rights by a parent or through permanent custody filed by the agency and then a full hearing after that. And then obviously the hope is that those children who are their parents' rights are terminated, the whole point is to free them legally for adoption so they can be adopted and have a forever family. So that's the hope there. All right, so hopefully I didn't spend too much time on that and bore everybody with the law. What I'm going to move on next is the, oops, forgot to show you guys that slide. I'll let you look at it for a second. So tools used by the court in the cases involving domestic violence. These cases are particularly scary for court staff because we know what's at stake, and we've seen what can happen when people don't comply with court orders. And we all know that at the end of the day that, if an abuser wants to accomplish a certain goal, he or she will stop at nothing, regardless of what court orders are in place or a TPO or a CPO or anything like that. So we do take them very seriously. And so now I'm going to talk about a couple of the specific tools that we use at the court in these cases. All right, so the first one is a no contact order. If we get a complaint, it says there's domestic violence between mom and dad, with the kids in the home or whatnot. The first thing that we do is to separate the parents and order them to have no contact with each other. It's a really easy thing to do and say at the court, but we're not dumb. And we know in reality that if people want to get together, they're going to get together outside of the court. But then when that happens, it jeopardizes the ability of the child or children to remain in the custody of the non-abuser if that's what the court has decided that it wants to do preliminarily. So we issue no contact orders, and usually now what we do is, especially if there's significant allegations of physical harm and domestic violence, we'll put ankle monitors on people, both mom and dad, because then we have a GPS monitor that tells us where you are at all times. And does this sound a little overreaching by the government, a little draconian? Yes, maybe, but it's also a way to keep people from being physically assaulted and put in the hospital, because we've definitely dealt with that. So we'll put an ankle monitor on both mom and dad. We have somebody who monitors it here. We make sure that they don't come close to each other. And that usually works unless people cut off their monitors or don't charge them on purpose so the battery dies. There's also the issue of who pays the cost for that. Sometimes the court pays the cost, sometimes JFS, sometimes the parties if they have the financial means, but usually they don't. The other tool that we use are unannounced home visits. If we have a case and we think that the children can remain safely with mom and mom will be able to meet the kids' needs, as long as we remove, dad or the abuser from the picture and we eliminate that variable, if we think the kids can remain safely with mom, we would like to do that at all costs, because we all know that removing kids from homes is traumatic on them and it's the last resort. And the only reason we do it is because the harm that could come of them if we don't remove them, that outweighs the trauma that they, could potentially experience by being removed. But so we will institute unannounced home visits by the agency and their employees, by court staff, by the CASA or the guardian ad litems. And we have a constable here at the court as well. So we'll just have people go over and randomly check all the time. And does that sound overreaching and a little intrusive and a little draconian measure by the government? Yes, it probably does. But again, if that's what we have to do to try to keep the children safe, but also in the custody of a parent, then we're going to do that and we're going to give it a shot before we go and remove these kids. The other thing that we use in these cases, in a lot of cases, is supervised visitation. When we're dealing with domestic violence cases, we will, a lot of times in other cases, we will allow family members to supervise, especially if we're just dealing with, a parent on drugs, something like that. But I don't believe that in significant, serious domestic violence cases that it's okay to have family supervise. I don't think it's safe, and it's just a good idea to eliminate that variable. So we have supervisors that the court pays. JFS can supervise as well. And we also have therapeutic supervisors, which they're essentially counselors. So it's basically adding a therapeutic component to a visitation between a parent and a child, especially if they haven't seen each other in a while, like if we've stopped contact, and then we're now trying to reinitiate contact. It's really helpful to have a therapeutic component there and a counselor. We also have law enforcement presence, either on call or just present at the visit in the building to be available. The setting of the visits can vary. The most controlled setting would be at JFS's agency. They have a visitation room set up in a family-like setting, and everything is video monitored, everything's recorded. So the most controlled setting would be at JFS, supervised in that room by a JFS worker. We can also use counseling agencies. Sometimes people are more comfortable there. Sometimes kids are more comfortable there if they've been having a long established relationship with the counselor. And, I don't know, Crossroads is okay with having it there, then we'll do it there if that, makes the child feel better. We've also had them up at the court too. We have security here. We have a facility and the means to be able to do that. We also use this approach if we're dealing with a parent who's on methamphetamine. I'm not going to order a court visitation supervisor to go to somebody's home and have the visitation there because there's probably meth residue in the home. So we use the highly controlled environment when we're dealing with the meth cases as well. I also like to require the supervisor of the visit to draft a report of the visit and the things that he or she observed, any concerns, any positive, great things that came out of the visit. And I like those filed, I don't know, within 5 days of the visit, and I read them because I want to know what's going on, and I want to know what's going on from this trained supervisor's point of view. What is he or she seeing? What is the impact on the children? Are they doing okay? The other tool that we use is show cause proceedings, and that's basically holding somebody in contempt of court for not following a court order. And this happens a lot when parents continue to have contact with each other. And it happens a lot even when they have ankle bracelets on and GPS monitors. So I will talk about that more specifically in a little bit. Towards the end, I have a specific case example. I've changed all the identifying information, but we used a show cause proceeding in that case, and I sent dad to jail for 30 days and mom to jail for 7 days. And it made me feel real bad. And it was a couple years ago, and it was probably the first time I ever sent somebody to jail for a full 30 days, but it was probably the best decision that I ever made for them. So I will get to that in a little bit. But basically, you have to prove at that hearing that someone has violated a court order. And if they've violated a court order, then you find them in contempt of court for having violated the order. And that contempt is punishable for the first time by up to 30 days in jail. You can send them to jail immediately. I could give them 30 days and suspend it and say, I'm going to suspend this on the condition that you do X, Y, Z and obey all these orders. But we're already here because they didn't obey the orders. So sometimes that gets a little dicey. I can make them serve some of the time, and then I can let them out early, on the condition that they go to a shelter or go to Women's Safe or do, X, Y, Z that I've already ordered that they haven't started doing yet. Sometimes it's a way to reach people and get their attention. It is the last resort. Definitely don't take sending people to jail lightly, but sometimes it needs to be done. We order people to complete aggression assessments, and I know Judge Topeka does the same at juvenile court. A lot of times we'll have cases that overlap because the abuser will be in Judge Topeka's court and in Muni court for, DV or disorderly conduct or whatever criminal charge, but then the family will be in juvenile court for the abuse, neglect, dependency case. So a lot of times we'll have kind of overlapping orders, or I'll adopt all of the bond conditions in my court as an order that Judge Topeka has ordered. But in any event, we order the people accused of the abuse to go get assessed by Ravenwood, Catholic Charities, various agencies to see what level of risk they pose, and, get specific recommendations from qualified clinicians as to how we help rehabilitate this person and get them to stop engaging in domestic violence behavior. There is a family violence intervention program. The one I'm referencing is specifically at Catholic Charities. And when we do have, verified abusers in court, and they've been convicted of domestic violence and there's CPOs in place, but it still remains an issue for whatever reason, we'll send them to the Catholic Charities program. And I forget how many weeks it is, but I want to say it's like 20 sessions or 25 sessions in a row, something like that. And there's a whole host of other assessments that we can order people to undergo and have them evaluated for different reasons and different issues, and get recommendations from the people who are evaluating them as to the proper and the most effective services that we can put in place at the court to help rehabilitate the behavior and then ultimately reunify the kids with a parent, one or both parents at the end of the day. I probably should have mentioned this at the beginning, but I'm happy to take questions at any time. So if anybody has a question, don't worry about interrupting me. So FYI.
I will interrupt. There
Oh, sure.
was a question that a few people have sort of responded to, but I wanted to make sure you had a chance to address it. Someone asked, are there any organizations that provide financial support for counseling for DV victims and involved children?
Specific organizations. I mean, at least in our court, there's no organization that we would reach out to say, hey, can you help pay for the cost of this counseling? Usually it's paid by, the vast majority of our people are on Medicaid. If they're not on Medicaid, they qualify and we get them on Medicaid, or JFS helps to get them on Medicaid. And if Medicaid won't pay for it, I mean, the court pays for a ton of stuff for kids. I'm never going to turn down an expense or an invoice for a child who needs counseling and has no other way to pay for it. So between the court, the CASA program, and the 501c3 that's associated with the CASA program, the Hearts and Hands, and also the resources at JFS, we pretty much get everything paid for, one way or the other. So I have not seen a child go without counseling services due to lack of money. I
Okay.
have seen a child go without counseling services because of wait lists and lack of availability at the agency, but never because of money. So yes, thank you for that question. I appreciate it.
Yep. A couple people just had mentioned the Family First Council in Geauga County, as well as Women Safe would be resources for, just in case anyone didn't read the whole chat. Those were the answers that I saw from the group.
I was going to
Thank
say,
you.
Lisa, it's Mary Ruth. Just really quickly, in Geauga County, Family First Council is going to cover any counseling that's needed, therapy that's needed that they can't afford. That's in the mental health board.
Right. If Family First is if they actually recommend, if they're making a recommendation for counseling, then they're way more inclined to fund it versus if the order comes from the court first and then you go to Family First Council and ask them to pay for it, then that gets a lot more difficult. But if it starts at Family First, they're the ones that make the recommendation and then we carry out their recommendation. Yes, they are much more apt to pay for it.
All right. Well, thank you.
Yes. Oh, sure.
I was
Any
going to say
other
thank you, and people can continue to put them in the chat if they have other suggestions, but that was the only question I noticed.
Okay. All right, great. So I'm going to move on to, all right, so I've covered the tools that we use, and now I'm going to move on to the common challenges that we see when domestic violence is a part of these cases. So first on my list is housing for the victim and children, which I'm sure everyone can commiserate about, everybody who's watching this conference, because I think that's a barrier that we all struggle with dealing in our cases, however you're situated in approaching the case. Sometimes the shelters are the only option, but it's been my experience from my vantage point at the court that a lot of people don't like staying at the shelters because, well, there's a lot of reasons. Because it's not home. So they're not staying at their house and, you know, everybody feels more comfortable at home. But usually what I found there's rules, but they're normal, rational, reasonable rules, but a lot of people don't like them. There's curfews. A lot of people don't like that. There's communal living, and you need to be considerate of others and pick up after yourself and supervise your own children. And a lot of people have a different way of picking up after themselves and supervising. And a lot of people consider themselves to have picked up or be supervising when, you know, maybe by somebody else's definition, they're not. So it's hard to live with other people and it's hard to follow the rules. You know, living communally, and drugs and alcohol are prohibited. And so that's really a hard thing for a lot of people when they go to the shelter because they are used to using drugs and alcohol. So what we see is that a lot of people leave on their own volition because they don't want to follow the rules and they don't like the shelter. And then a lot of people are asked to leave or they're kicked out due to their behaviors. You know, sometimes they actively engage in offensive behaviors. Sometimes it's just they have refused to follow the rules and, you know, the time has come for you to leave the shelter. What I have found is that the shelters are very good about giving warnings and an end date and helping to come up with a plan to help that person transition and find another place if they are going to be asked to leave. And when people are asked to leave, they often go stay with relatives. And a lot of times these can be much less safe placements for kids because they're staying with people who have their own drug and alcohol issues or mental health issues or child protective services issues. And so, you know, if we gave custody, you know, left custody of the kids with mom because we knew she was going to stay at Women's Safe, we felt pretty good about that. But if mom leaves and then goes and stays in, you know, someone's couch and living room with the kids and we don't think that's a safe environment, then that could sometimes jeopardize, you know, mom keeping the kids in her custody. Let's say that somebody wants to go to a shelter and they're willing to go and to comply. There's still wait lists and there's still a lack of available space. There are wait lists for public housing. There are wait lists for subsidized housing. So there's there's just not enough housing to go around, but that's not telling anybody anything new. I think we all know that. But it's a real struggle, and it can really complicate things. I will say that JFS is really great about paying for parents and kids to live in a hotel or something like that for a short period of time, or I've even seen it up to, I don't know, maybe even 30 to 60 days, but JFS is willing to do that in some cases to pay for families to stay in hotels and motels. The other common challenge is mental health issues, or just kind of the victim presenting as a little scattered and just lacking that mental stability that we would want a parent caring for children to have. I understand why it's lacking. I'm not criticizing. I understand why it's there, but if mom is so traumatized and the response to the trauma is manifestation of mental health issues, is it significant enough to say that the kids aren't safe? I don't know. We oftentimes have to make that call, and sometimes it can change, and sometimes, the pattern isn't linear and it's up and down. There is often a co-occurring substance abuse drug problem that a lot of the victims have. And again, I understand why it's there, and I'm not criticizing. I think it's just another response to trauma and to living in misery, and it's self-medicating. So it makes sense why someone would turn to that and have that co-occurring disorder when they are living in such chaos and distress. When your mental health is unstable and or you're addicted to substances, it's really hard to get a job. And if you have one, it's really hard to maintain a job. And if you don't have a job, it's really hard to support yourself and your kids. And so we address the mental health and the drug problem first, because if we can't get that under control, then it's really hard for all of the other things to fall into place. And the challenge, and again, I'm not telling you all anything new, is that this can take a really long time to get the mental health and the drug use stable, so that mom's stronger and then can move on to the other things that that are on the case plan and that need to occur before reunification can happen. But that can take a long time. And again, going back to the timeline that I told you guys about at the beginning, when you put those things up against each other, it really doesn't leave us with a lot of time, and it can be hard. This is a big one, but continued contact between the parents despite the court order prohibiting it, and additional incidents of domestic violence that occur after our court case has started. I can tell you personally, when additional incidents occur, I feel like a failure. I feel like I've jeopardized someone's safety and that I've caused it to happen. Obviously, my feelings are clearly secondary, but that just goes to what I said at the beginning, is that these cases are really scary for us. So when these additional incidents occur, it's very jarring, and it's a reminder of just how serious and dangerous of a situation that we're dealing with. And these continued incidents, the additional incidents, I will say that if the children haven't been removed already, they're going to be removed now. And the response, and I'm not saying that this is right, and this is going to get to my next point, because I'm going to ask you all for some help. The response from usually the treatment team and everybody involved is, well, mom can't keep the kids safe. Dad's gone to her house and done XYZ again, but, mom can't keep the kids safe. She can't keep dad away. So we are going to remove the kids because they're not safe in that environment. And it's a totally unfair mindset, and it's really troubling. And I feel like I'm in the middle of it, and half the time I'm perpetuating it. It's not the mom's fault that the kids aren't safe. It's the abuser's fault, and the focus should be on the abuser's behavior. But that's not necessarily what it is, what the focus is on. And at the end of the day, my job is the best interest of the kid and to keep them safe. So if, regardless of whether the mindset is wrong, if the kids aren't safe, that's the reality of the situation, then they need to be removed and put someplace safe. So then the next challenge I was going to get into was the mindset about the victim, and the victim being responsible to comply with everything in the case plan to get the kids back, because we can't rely on the abuser, and we can't. Because I'll tell you, the abusers in the court cases that we've had, they don't come to court half the time. And if they do come to court, it's because they're in the custody of the Geauga County Sheriff out of Chardon Muni Court. And so we can have them hauled up to court. So it's basically like they're a captive audience, but they're very hard to control, and they don't come to court. We can issue bench warrants, and then they get picked up, and we bring them in and we send them to jail for 30 days. But, you know, the whole thing just ends up repeating. So back to this mindset about the victim. I mean, the children need to be put first, and we know the abuser isn't going to do it. So we look to the other parent, the victim, to do it. But they're not always ready to do that. They're not always capable of doing that based on the trauma, the mental health issues, the co-occurring substance abuse issues. So how does the court handle that? We handle that by putting the kids in a safe environment. And sometimes that means removing those children from the victim. And when that happens, I sometimes feel like I'm, you know, re-victimizing the victim all over again, and the kids are being punished. But like I said, at the end of the day, the kids need to be someplace safe. So that's a really difficult conflict that we have. And I would welcome and appreciate any words of wisdom, suggestions, any 2 cents, any thoughts that anybody has as to, one, how we kind of reframe our mindset, and 2, some helpful tools that we could actually employ in reality during the life of these cases to, I guess, control the abuser more than rely on the victim. I don't know if that makes sense. I hope it does. Another challenge is the parents' right to see their children. Parents have parental rights. Until we terminate them or they surrender them, they remain intact. And do we force kids to visit? If we don't, and I order no contact, how long does that continue before we reinitiate contact? Or does so much time pass that it's too hard to reinitiate contact, too hard to reestablish a bond and to reunify? How do we balance this for kids and make it safe? I don't know. I don't have the answer. We just try our best every day. I have a case right now where, quite frankly, I don't think the kids should be visiting with the other parent, and I thought I had made an order to that effect, but apparently it wasn't that clear. And so the kids are visiting, but they're visiting in that very controlled environment at JFS and supervised by JFS. There's law enforcement there, and there's also a safe word that the kids can say if they're feeling uncomfortable or anything like that, and they need to the visit to end. So I feel like we've done enough to make the kids physically safe for the duration of the visit, but if it takes having law enforcement and giving these kids a safe word, is it really in their best interest to be visiting with this person? I don't know. And I've only had 2 hearings, so I don't really know enough yet to make that informed decision. And I just rely on the information that people present to me in court, because that's what I have to go on. I can't go out and do my own independent research. So I rely on what people tell me, and I make decisions based on what people tell me. So obviously I'm having some heartburn over that case because it just doesn't sit well with me. And like I said, I don't have an answer. Do we force kids to visit? Sometimes yes, sometimes no. How do we balance this, and how do we make it safe? A lot of times I ask for input from their counselors and therapists. Sometimes I get it and it's really helpful. Sometimes the therapists don't feel comfortable making that recommendation, or they feel like it's out of the scope of their professional capacity. And I have to respect that. But then, I still don't get any of the helpful, meaningful input as to how I make things okay for this child, during a visit. And then the final challenge I have on here is that there is no co-parenting in DV cases. The abuser does not want to work together with the victim. The abuser wants to create chaos and make sure that chaos reigns throughout the entire case. So it's really hard to reunify in those situations where there is no co-parenting, and the victim is working as hard as he or she possibly could, but then the abuser just does things to jeopardize the safety of the kids and essentially sabotage the progress that the victim's making. And it's hard. I did add something here in my notes. Other factors impacting visitation and the frequency. The COVID restrictions has made things difficult and kind of put things on hold for a little bit, although they started again. And JFS isn't, sometimes they have a lot of turnover and staff shortage, and sometimes they don't have people available to supervise in their building at that room, as I have ordered. So sometimes that can kind of impact the frequency of visitation and whatnot. I think, all right, I got 10 minutes. So I'm going to move on to my case example, and then hopefully some time for questions. So I appreciate everybody listening.
There was a quick question.
Sure.
On the reunification. So before you move on, since you were just talking about it, someone asked, is the current goal reunification in general for children in DV cases within the court system?
Yes. So our goal is pretty much always reunification unless the agency files a complaint that contains a prayer for permanency. And so that's basically the agency's filing a complaint and they're saying right out of the gate, we're going for PC at that disposition hearing that happens within 90 days. And if they did that, it would be because whatever family they filed on has such a lengthy and egregious history that they wouldn't ever do that unless it was really bad and really warranted, and they didn't think that we needed to try for reunification. And sometimes if you got some, awful, horrendous complaint for, sexual abuse by one parent against the child, and then it was adjudicated, I don't really know if the goal would be reunification with that child. Just to be honest, I think the goal would be getting the offending parent some sort of counseling and I guess tying up the legal loose ends of the custody with the other parent, and then trying to figure out if you could do, if contact between the child and the offending parent, if it would be appropriate at all. I don't know, but if it's some insane, awful, really horrible abusive case, then reunification wouldn't usually be our goal. But fortunately here in Geauga, we don't necessarily see those really, really ugly cases. So 99% of the time our goal is reunification. All right, so I have the Miller case here. This case came into us in September of 2019. There's two kids. They were ages 12 and 14, and they were mom and dad were unmarried. The allegations contained in the complaint, it was a dependency complaint, and the agency specifically alleged that mom tested positive for meth on a drug screen that she agreed to take for JFS. And she had disclosed to JFS that dad beat her up, and she was observed with multiple bruises on her body. Dad has extensive criminal history, a prior prison term, and a pending DV case in another county with a temporary protection order in place. And I think it was a felony charge. And if you're going to be charged with felony DV, you have to have, I think, at least 1 or 2 prior convictions in order for it to be enhanced to a felony. So he was no stranger to DV. And also, dad destroyed mom's car, so she couldn't use it in front of the kids. So those were the allegations in the complaint. The last sentence of the complaint, when I was preparing this presentation, really struck me. And this goes back to this mindset that we have that we don't want to have that I was asking for help for. Here's the last sentence of the complaint as written by the agency. The agency is concerned about mother's inability to keep the children away from father's violent behaviors. So that was in there. I don't know if it's fair or not, but that's what was in there. So they came in for an initial hearing. The kids were placed into mom's temporary custody. All contact was to be supervised by the grandmother who they lived with. And that's because mom tested positive for meth. So she was able to stay in the house with the kids and maintain custody of the kids as long as the grandma was always present and overseeing everything. There were other standard court orders put in place, like no contact between the parents, drug testing, they needed to sign releases of information, they needed to each complete a dual diagnostic assessment, and dad was allowed to have supervised visits with the kids with law enforcement present during the exchanges. And also we ordered that the kids get counseling needs assessments because we wanted to get them into counseling. All right, so that was in September of 19. In November of 19, the court had been receiving multiple reports of continued contact between the parents via cell phone. And then there was this incident in November of 19 when mom was hospitalized. And she had to disclose to the agency that dad beat her up. It was in another county, it wasn't in Geauga. And she went to the hospital. She may have had a fractured orbital bone or something like that. So mom disclosed this to JFS, but then immediately recanted and said nothing happened. I don't know what you're talking about. And mom and dad were the only two people present during this incident. So JFS did not ask for show cause for violation of the court order, and Judge Rendell, who was handling it at the time, did not either. We made the decision, well, one, how can you prove it if they were the only two there and mom's not going to say anything? And two, if we force this, we're really just jeopardizing mom's safety more, is what I really thought. All right. And so at that point in time, around that incident, when mom got assaulted again, there was a relative in mom's house who ended up testing positive for cocaine. So judge decided, all right, enough is enough. These kids are going into temporary custody of the agency, and the agency placed them into kinship care. And we were very lucky that there were relatives ready, willing, and able to take these kids in, so they didn't have to go to foster care. But that availability isn't always in existence. And then the parents were put on GPS monitors. So after that, dad threatened the kinship caregivers and made a bunch of threats and allegations. It freaked them out. They weren't sure if they could keep the girls and subject themselves to this and maintain the placement. But we got things calmed down, and ultimately the placement did not disrupt. I think that JFS maybe hired private security for a weekend at the beginning of the threats. All right, so that's in November. Here we are, January 2020. Alerts go off of mom and dad both separately tampering with their GPS monitors and having additional phone contact, and dad has a bunch of pictures of mom and sexually compromised positions on his phone. So they have contact, and dad actually ended up taking off his GPS bracelet. We don't know how he slipped it off, but he did. So long story short, we had a show cause hearing, and I found dad in contempt for having removed his ankle monitor, and I sent him to jail for 30 days. And I made him serve the whole 30. I found mom in contempt for having contact with dad, and I sent her for 30 days, but I brought her back a week later, but just her. I brought her back from the jail for a review, and my plan was to let her go and suspend the 23 days on the condition that she goes to Women's Safe, gets herself into a shelter, starts to comply with the case plan, starts to get some counseling, and let's pull your head out and move forward in the right direction. So this was my attempt at getting her attention, and she was really active on meth, and I thought 7 days in jail would, one, get her attention, and two, help her detox from the meth, be thinking a little bit more clearly when she comes back from court. So she comes back 7 days later. I release her. I suspended the remaining time on the condition that she obey those orders. And I left Dad in jail for that full 30 days. So she had a solid 3 weeks of complete separation from him and got that, 3 weeks worth of a head start. So after this, Mom continued to test positive for meth for several months, and Dad barely ever showed up to hearings and was in and out of jail and treatment centers, and I don't know, I think even caught federal charges on something. So he just turned into a hot mess and spiraled out of control even further. And his incarceration actually, I really think, helped Mom, because it really helped him not menace her and harass. And if he wasn't there with that insidious, incessant contact, she had a much better time of breaking away. And that's what happened. So that was January of 2020. She continues to use for several months. And then come September of 2020, she finally goes to inpatient treatment. She completes it. She gets a job. She stayed clean. She worked the case plan. She did have one slip, but it was just one positive mouth swab test, and all of the other tests were negative. She ended up getting a promotion and maintained the kids in their counseling sessions, and then eventually the kids were transitioned from the kinship back to Mom's home. And in June of 2021, this past summer, custody was restored to Mom. Then we monitored for one more 3-month period. And then in this past September 2021, we closed the case, and we made some continuing orders for no contact against Dad to try to take the heat off Mom so she didn't have to be the gatekeeper. But essentially we closed the case, and we hope for the best, like we do with all of them. So not all of the cases turn out that way, but that Mom was one tough cookie, and she really persevered for months and months and months, and her love and commitment to her children really shined through. She got herself on track, and one, she got herself off of meth, which is never easy, and two, she broke away from the abuser, which isn't easy either. So that was really great. So I'm at 152. All right. Anybody have any questions or anything else you'd like me to elaborate on? I do appreciate everybody paying attention and listening to me and whatnot. Hopefully this was somewhat helpful.
Yeah, we had a few people just with some praise that this was very timely and helpful for someone's cases they were working on. Great training, very informative. Incredible role that you have in helping victims. You're a blessing to the families you serve.
Oh, thanks, guys.
A couple of thank yous coming in. I don't know if Natalie is still here. She asked a question earlier about how victims and children are further protected during DV cases when there's post-separation abuse, which I think you kind of covered. And then she said interesting in response. So Natalie, if you had any further follow-ups, I wanted to make sure we didn't miss that question.
Interesting response, as in when I said we kind of close the case and hope for the best.
Yeah, you were talking about it earlier with how you you may have to separate the victim even though the perpetrator is the one doing something wrong. It was a little bit ago when you were talking about it. So I think that she was responding to what you had said. It was just perfect timing that you kind of answered the question when she asked it.
Oh, got it. Okay.
Just some more thank yous. Nothing, no other questions that I'm seeing so far.
Well, thanks everybody for the feedback. And I recognize the important role that you all play in these cases. And it's always nice to see the variety of professionals come to our hearings and participate and advocate for the families. And all of your hard work does not go unnoticed. And I will say, I'm available if anybody has any other questions and wants to just give me a random call at work, as long as it's not about a case or anything specific and it's just a general question or anything like that. I'm always available, happy to speak with people.
All right, well, thank you again. And if you didn't see in the chat earlier from Liz, the session code for this is court. So like you go to court.
Yes.
And I'll throw it over to Liz to maybe wrap up for us if you would.
Absolutely. I sent that. Yeah, I sent that one to, it was just a few minutes late. Thank you, Lisa, for sending that back out, but I sent that one to someone individually.
There's my contact info if anybody wants it.
Perfect. Thank you so much. And yes, you have so much great knowledge. So, and it's a lot of, you had kind of mentioned it where, you know, there's some times where we can't provide you the information it is that you need because of, you know, our board and what our board tells us to do. But thank you so much, Magistrate King, for being able to share your insights and things like that as well. So
Absolutely.
greatly
Thanks for having me.
appreciate you.
Thank you.
And so, as we had already said, the session code for this one is court. At 2 o'clock, there should be an email that goes out to everyone involved for today that will have a list of all of the surveys. And just a note that we've been calling them session codes, but they are actually the passwords that get you into the SurveyMonkey. So, so make sure that you remember those. And then I just wanted to thank Family Pride as well, because Family Pride and Nicole have been huge in being able to provide these CEUs. So they were able to put all of these surveys together. And so it's just been phenomenal to, once again, the second year in a row, Family Pride is being able to provide us these CEUs. So we greatly appreciate that. There's also one survey that is just focused on our questions for helping us plan for 2022, because we would love to keep this going. And maybe one of these days we will be in person, but the virtual does a really great job because we were able to see that folks were coming in and leaving throughout the day as when they had that availability. So yeah, so it's fantastic as well. And I do have to thank Lisa as well for assisting with all the presentations and things like that. And as well, just the whole entire task force. So we would like to thank you all on your all behalf for contacting all of our presenters. And if you have not signed up for day 2, you still are able to sign up for day 2. So we have 4 more presentations going on tomorrow, so 9 to 1. We will be doing that as well. Did I forget anything, guys? No? All right, fantastic. Well, look at that. You're getting out 5 minutes early. So thank you so much. And for those of you that are joining us tomorrow, we'll see you tomorrow. The code word is court. I'll hang out for a little bit more to see if there's anybody else that has questions about code words.
Someone also asked me about Aaron Turner's email, so I will put that in the chat as well.
The link for tomorrow is not in the survey. You should have gotten an email this morning around 9 with that link information for you tomorrow. Bianca, if you have any other questions, you can feel free to email me, cco@womensafe.org, if one of you wouldn't mind typing that in there really quick. Perfect. Thank you guys for being my typers. All right, fantastic. Thanks, Bianca. And thank you, Sierra. Yes, we have, I feel like I have learned a lot as well today. So it was a fantastic day. I'm looking forward to tomorrow. All right, I guess I could have